Good morning, this is Melanie Daly here with the Daly Grind, having a morning cup of coffee as we discuss another workers' compensation issue. Today we are going to talk about the issue of loss of use, which occurs at the time of permanency. If the claimant has sustained an injury to the extremity, we're going to be talking about extremities today only, but it's basically the loss of use is the loss of earning power that they may experience as a result of the loss of functional abilities of that extremity. So at the time of MMI, the claimant will essentially go to his treating provider, and his treating provider will fill out the C4.3, which is the permanency form that is required to be used to provide an opinion on permanency. The doctor will at that time decide that the claimant is in fact an MMI, and that the range of motion measurements of that extremity will be taken in order to see what the loss of use is that should be awarded to the claimant. This usually occurs at the time when the claimant is working full-time, full duty. There is recent case law and litigation that has touched on that, whether or not the claimant should be attached to the labor market, but we will cross that road in another episode. Today we're just going to focus on the examination itself. So basically the way we take it is if the claimant is in fact working and awards are not ongoing, then we essentially like to wait until the claimant did get a permanency opinion, or depending on the facts and circumstances of the case, but typically I like to see what the doctor comes up with first. And then we decide whether we need an IME or whether we should just try to refute the doctor's application of the guidelines and the measurements. So essentially when we first get a C4.3, we look at the range of motion findings of the claimant at that time. We look at the guidelines, whether any special considerations apply. There's a situation in each chapter of the impairment guidelines, which for each extremity there's a list of special considerations that the doctor has to consider when he's considering the loss of use, and we will also touch on that sometime in the later future. However, today we're talking about the measurements, and what we focus on is whether the measurements of the claimant at the time of permanency are consistent with the range of motion throughout the entire exam, as the guidelines indicate that the claimant's range of motion has to be taken on an active basis. So therefore, it's essentially subjective. It's how far the claimant is showing this doctor that he can lift his arm. And there's really no objective way to see whether or not that's how far he can lift his arm. So we really like to scrutinize these opinions to see, A, did he apply the guidelines properly? B, are his range of motion findings consistent with the record to date? A lot of times we'll look through the record, and throughout the entire history of treatment, the claimant will have almost full range of motion. And then at the time of permanency, likely when they know that a payment depends on that exam, there are limitations that tend to become a little more extreme. So we always look for that. Even in physical therapy records, if there's a history of the claimant being able to move, the extremity a certain way, and now all of a sudden he can't, it's not credible. And at that point, we would depose the doctor. And there is clear case law that indicates that if the claimant has an unexplainable decrease in his ability to, exhibit full range of motion or close to full range of motion when he had been doing so the whole time, the doctor you got to put the doctor on the spot on that and find out what happened between these appointments and this appointment that caused the claimant to deteriorate so much. And if he did in fact deteriorate that much, then how would he possibly be an MMI, especially when he was exhibiting full range of motion prior? So essentially, not that we want to extend or delay permanency, but it's a viable question that you should be asking the doctor. And because a lot of times it is just the claimant, and it's up to the claimant's subjective attempts and subjective efforts that really determines the loss of use. And also, one more note on that is typically carriers will obtain an IME on permanency also. But usually when the opinion is so bad from the treating provider, we would typically, in some circumstances, recommend not even getting an IME because that could possibly result in the claimant, again, exhibiting range of motion measurements that are much lower than he had been previously. So not only now would you have to argue against one opinion, but you would have to essentially argue against both. And one of them would have been your doctor. So that's kind of difficult, but it depends on the case. So if you have any questions, feel free to give me a call or an email. My email address will pop up on the screen. If there's anything that you want to hear about and talk about over your morning cup of coffee, then let me know and I would be happy to discuss it. Thank you.